In today's news session, we begin with a significant ruling from the United Kingdom Supreme Court regarding the conjoined appeals of Daly and Keir. This decision mandates changes to the manner in which Scottish courts admit evidence related to sexual conduct. Next, the Criminal Cases Review Commission has referred convictions from a high-profile joint enterprise case in Moss Side to the Court of Appeal. Lastly, Peter Sullivan, who spent 38 years in prison before his conviction was overturned, is now publicly requesting an apology. He claims that his original confession was coerced due to police pressure. Stay with us for full coverage of each story and an explanation of their importance.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Thanks for joining us. Get comfortable and let's jump straight into it. When discussing miscarriages of justice and flaws within the criminal justice system, attention often turns to appellate courts and processes. But it's crucial to remember that the first opportunity to get things right is at the trial itself. Today's stories look at how the use and sometimes misuse or even concealment of evidence can create injustice from the outset, and why this must be avoided at all costs. We will explore how the criminal justice system works to balance truth-finding with fairness. On the 12th of November 2025, the United Kingdom Supreme Court handed down a judgment in the conjoined appeals of Daly and Keir. The court dismissed both men's appeals on the facts, but delivered a significant ruling about Scottish evidence law and the right to a fair trial under Article 6 of the European Convention on Human Rights. Both Daly and Keir were convicted of serious sexual offences in Scotland. They argued that the trial courts had excluded material and lines of questioning about complainants' prior sexual behaviour in a way that prevented proper testing of credibility, raising concerns about Article 6 rights. More specifically, the cases were concerned with the application of sections 274 and 275 of the Criminal Procedure Scotland Act 1995. Now, section 274 prohibits the introduction of evidence or questioning which concerns the character, behaviour or sexual history of the complainer. However, this prohibition is not absolute, and an exception is provided in section 275, which is available if the defendant makes a written application and the court is satisfied that the criteria specified in the legislation are met. Namely, tests that relate to the specificity, relevance and probative value of the evidence, which are principles developed at common law. To simplify, courts should only allow evidence that's clearly connected to the case, genuinely useful in providing something important, and specific to the issues being decided. To use an analogy, think of a court case like packing a suitcase. Relevance is only packing things you actually need for the trip. Probative value is making sure what you pack is useful, not just taking up space. And specificity is choosing items for this trip, not random things from your wardrobe. So if it doesn't help, doesn't fit, or isn't meant for this trip, it stays out. In the specific case of sexual offences, the evidence probative value must be significant and must outweigh the risk of prejudice to the proper administration of justice, having regard to the protection of the complainant's dignity and privacy. These provisions exist to protect the complainant from unfair and intrusive questioning and to prevent the jury from being improperly influenced by evidence that is irrelevant to the charge against the defendant. Now, though the Supreme Court unanimously dismissed both appeals and found that in the specific facts of each case neither man had been deprived of a fair trial, the court went further. It found that the broader Scottish approach to admissibility, in particular the interaction between sections 274 and 275 and the common law doctrines, have developed in a way that risks infringing Article 6 rights. These common law rules have often treated certain type of evidence, especially anything involving the complainant's sexual history or personal behavior, as irrelevant or collateral. That has resulted in the exclusion of evidence the defense argues is crucial for testing the complainant's account. The Supreme Court's message was clear. This approach is too rigid, too categorical, and incompatible with the demands of a fair trial. The statutory scheme must be applied as a unified framework, allowing relevant defense evidence where the probative value outweighs the risk of prejudice. In short, blanket exclusions are out. Judges must undertake a careful case-by-case assessment of relevance and probative value, balancing a complainant's privacy and dignity against the accused's right to challenge the case against them. That means more flexible admissibility assessments and clearer reasoning from appellate courts going forward. But implementation poses risks. The judgment sets out principles rather than a single bright line test, meaning lower courts, prosecutors and defense teams must adapt, which is likely to result in transitional uncertainty and inconsistent outcomes. Whether this judgment will deliver the meaningful shift in practice that the Supreme Court envisages is a question that only future cases can answer. The true measure of its impact will lie in how lower courts interpret the principles, how consistently they are applied, and whether they lead to fairer and more transparent trials. And for those of us in England and Wales, an important question now arises. To what extent will this ruling shape the government's reception of the Law Commission's final report, Evidence in Sexual Offences Prosecutions, which was published on the 22nd of July 2025. As you may remember, in this video, we explained the Law Commission's proposals and expressed reservations about whether some of the suggested reforms were truly compatible with the fundamental purpose of a criminal trial. The Supreme Court has now reaffirmed that purpose with clarity. A criminal trial exists to determine whether the defendant is guilty of the offence charged and, if so, to impose a just sentence. At the heart of our system is the principle that innocent individuals must not be convicted or punished. If the primary aim of the trial is to guard against wrongful convictions, then any reform must be approached with great care so as not to recalibrate the process in a way that jeopardizes that essential safeguard, however well intended the change may be. While the Law Commission reform proposal appears, at least in principle, to be aligned with the Supreme Court's reasoning, in that it avoids any automatic exclusion of potentially relevant but sensitive evidence, the practical effect of its proposals remains uncertain. Much will depend on how these recommendations are ultimately drafted, implemented, and applied in real cases. Against that backdrop, it is entirely reasonable to expect that this judgment will exert significant influence on how the government evaluates the Law Commission's proposals and on how any eventual reforms are shaped in legislation, guidance, and judicial practice. And speaking of wrongful convictions, our next story concerns Peter Sullivan, a man whose conviction for the 1986 murder of Diane Sindall was quashed early this year after decades behind bars. In his first major interview since release, Sullivan has publicly demanded an apology and described the circumstances that he said led to his false confession. His case is powerful and painful. It raises urgent questions about police conduct, vulnerability in custody, and how miscarriages of justice are remedied. Peter Sullivan, now 68, told reporters he was bullied, beaten, and deprived of sleep and food during police interviews, that officers threatened him with further charges and pressured him until he gave in and confessed. He says he has learning difficulties and was denied an appropriate adult during those early interrogations. He said that the first confession was not recorded and that he later retracted his statement when legal advice was finally provided. According to The Guardian, Merseyside police have acknowledged the miscarriage of justice in the broader case, but said this is the first time that we are aware that this allegation has come to light, and materials from the time we have access to do not provide any such details or allegations. They added, "We understand the detrimental impact the conviction has had on the life of Mr. Sullivan and do not underestimate the significance of being imprisoned for 38 years on his well-being. We are doing everything we can to find out who the new DNA evidence, which formed the basis of his release, belongs to." Sullivan has made two public requests: an apology from those responsible for his wrongful imprisonment and compensation to help rebuild the life he lost. He told interviewers he needs an apology to move on, saying he missed key family moments, including his parents' funerals, while incarcerated. His legal team are pursuing compensation, but as we know, this is a slow and complicated process. Beyond Sullivan's personal tragedy, the case highlights systemic risks. Suspects with cognitive vulnerabilities being interrogated without proper support, unrecorded or improperly conducted interviews. His story underlines why robust custody safeguards, full recording of interviews, access to solicitors and appropriate adults are essential to prevent future miscarriages of justice. Although significant progress has been made in how police interviews are conducted, problems still persist, as we discussed in our interview with Ian Ross, which we strongly recommend watching if you haven't already. And lastly, we end with a story that really brings us back to a central theme of this episode: the way evidence is handled in criminal trials. On the 19th of November, the CCRC referred convictions in the Moss Side joint enterprise case to the Court of Appeal. The referral concerns convictions arising from the 2016 killing of Abdul Hafidha in Manchester and challenges the gang narrative that underpinned the prosecution's theory. 11 people were convicted after the trial in 2017, 7 for murder and 4 for manslaughter under joint enterprise principles. The prosecution argued that they were members of a gang and acted collectively. But the defendants who did not commit the stabbing, supported by their families, have all argued that they were not in a gang and had no intention that Hafidha would be killed. Campaigners have long argued the gang allegations were exaggerated, racialized, and relied on shaky inferences, including a rap video created as part of a youth engagement project that was presented at trial as proof of gang membership. Using our suitcase analogy, this item was placed there just to fill space and cause confusion, a decision plainly influenced by institutional racism. The CCRC says new evidence and expert analysis undermined the prosecution's central gang narrative and cast doubt on how jurors were directed about gang membership. The Commission concluded there is a real possibility the Court of Appeal may find the fresh evidence materially undermined the jury's conclusions, hence the referral. Dame Vera Bird KC, CCRC chair, said this referral highlights the need for safeguards to protect defendants against the risk of unfairness from a too readily adopted gang narrative based on inappropriate labelling. It is possible that there are other cases which would benefit from guidance on this issue, where the fear may be that stereotypes can be wrongly introduced as evidence. This only confirms campaigners' long-standing concerns that joint enterprise prosecutions have disproportionately affected black and mixed-race young men, that gang narrative can be racialized, and that evidence framed to produce a gang story can mislead juries. A referral does not guarantee quashing. The Court of Appeal will now consider whether the trial was unsafe in light of the new evidence. For the men involved and their families, the referral is a step towards a fresh scrutiny of their convictions and potentially a path to redress. So, 3 different stories, but one shared theme. How the criminal justice system balances truth-finding with fairness. From the Supreme Court in Daly and Keir demanding evidence rules be recalibrated, to Peter Sullivan demanding apologies after alleging coercive police tactics that produced a false confession, to the Mossad referral challenging a prosecutorial narrative accused of a racial bias. Each story pressures institutions to reform, to explain, and to rebuild public trust. That's all from Spoken Injustice today. As always, our final recommendations. Don't forget to support the channel by liking, sharing, and subscribing. Join us again as we sit and rise in this unique trial.